In this lecture today, we will continue to see the constructive trusts. When we talk about section 83 of the trust ordinance, we have highlighted two words there. Those are attendant circumstances. When we see section 83, just we will revise what we have done in our two previous lectures. Section 83 provides that the owner of the property transfers to another person. At the same time, such owner did not dispose of the beneficial interest to the transferee. Then the transferee must hold the property for the benefit of owner. If the owner is dead, then he must hold the property for the benefit of legal representative of such owner. Let's clear the section. As we have seen in our previous lectures, there are two words which are very important in section 83 of the trust ordinance. Those are attendant circumstances. What is known as attendant circumstances? How to identify the attendant circumstances? That's the issue we have seen in so many cases. We have seen a number of cases in this regard. Specifically, we have seen, first place we have seen the consideration. Now the owner transfers his property to another person. If such another person paid the market value of the property, that's the consideration to the owner, that is the end of such transaction. That's generally known as deed of transfer as well as absolute or outright transfer. But in a case where the transferee pays such amount of money which is not sufficient consideration for the property transacted. Now that's the issue. Insufficient consideration paid. Then what is the situation? Or sometimes we have seen cases also. The owner of the property transferred that property to the transferee, but transferee did not pay anything. No consideration paid at all. But there may be some undertakings. Sometimes the owner of the property is enabling the transferee to get a loan from the bank. Then the first place we have seen whether the sufficient consideration paid by transferee to the transferor. That also we must see whether there is a gross disparity in the price between the price that they have transacted really and the market value of the property. Suppose in certain cases we have seen the market value was something like 2000 rupees, but actually they transacted about 650 rupees. That's a big disparity. The gross disparity between those prices, some extent we can take the disparity as an attendant circumstances. But only the consideration or insufficient consideration or undervalue of the property, we can call it as undervalue of the property, does not amount to the attendant circumstances. But it is a factor, one of the factors that will bring, that will show the transferor did not dispose the beneficial interest to transferee. Then this is all in relation to the consideration. Then we have seen possession. Now generally when you talk about deed of transfer, as you have studied in the law of property, if A transfers the property to B, it should be in vacant possession. That's why we say that right to ownership and right to possession. There are two matters that should, when you transfer the property, the ownership and the possession should go to the transferee. But here, even though the property transferred and the transferee became the owner of the property, but the transferor is continued to be in the possession of the property. Then there is an issue, then we can, then there is a question, why did the transferor, or other way we can say, even though the property transferred, possession should be given, but here possession was not given to the transferee, but the transferee also agreed. That means there is an outstanding of beneficial interest. Even though the whole rights given to the transferee, but there is some or certain outstanding beneficial interest with the transferor. That means the owner of the transferor still has some sort of beneficial interest in the property. That's why still he is in possession of the property which was transferred to another person. Then that is also one of the factors in the attendant circumstance. Then the first one is consideration, whether insufficient consideration paid. Then second thing we have seen, that is known as possession, whether the owner is continued to be in the possession. That was one other thing we have seen. Then the other matter, who has paid these charges in relation to the conveyance. Now generally, if the seller wants to sell a land, then the buyer should pay notary fee and stamp duty. Always purchaser or the buyer must pay the notary fee and stamp duty. But in certain cases that we have already seen, even though the transfer deed was executed, but the transferor, the seller, who has paid notary fee as well as stamp duty. That means without any beneficial interest, why did this seller pay such amount of money in relation to the charges or in relation to the conveyance? Then there is some sort of beneficial interest with the transferor, otherwise he won't pay anything in addition to the transfer, in addition to any other things. He is not liable to pay anything, but he pays. legally he is not liable to pay, but he pays. That means out of that transaction, he is going to get some sort of beneficial interest. That also we can identify as attendant circumstances. Then that part also we have seen. Then the fourth one we have seen, the retransfer or reconvey agreement. It may be in writing or maybe notarially executed, maybe in writing but not notarially executed, or otherwise there may be a oral understanding between the parties to retransfer or reconvey the property to the owner. In the first place, if the reconvey agreement is executed in terms of section 2 of the Prevention of Frauds Ordinance, then there is no issue at all. That is a written proof for a reconvey, for the reconvey of such property. But if it is executed but not notarially executed, then what is the issue? Always we have seen in these cases, the defendant argues that this document is not at all valid because it is in violation of section 2 of the Prevention of Frauds Ordinance. Then what we can do is, in one case we notice, in Valyamiyachi case, we can get the help of section 5.3 of the Trusts Ordinance, and we can argue that there is the defendant right to or leads to the fraud. Then we can get the help of 5.3 and establish a trust. That's one thing. Or otherwise, even though it is not executed, now the concept here, there is a contradiction with the provisions of the Evidence Ordinance. Section 91 and 92 of the Evidence Ordinance prevents leading any evidence to prove or disprove a written document. That we have clearly seen in the previous lecture. Now I don't want to go back to that one. Then what the idea is, if there's a document which is in writing, cannot be contradicted by submitting oral evidence, by submitting parole evidence. Then what we have seen, according to the cases, decided cases, here in the trust or section 83, in terms of section 83, the plaintiff submitting those evidence not to contradict the document which is in writing, but to establish attendant circumstances in terms of section 83 of the Trusts Ordinance, under which there must be or there is a presumption that transferor did not intend to dispose the beneficial interest to the transferee. Then the purpose of producing oral evidence not to contradict the document which is in writing, but to establish the attendant circumstances. Then in this slide here, Hevage Don Piyasena versus Karunasena Katrasinghe, Supreme Court Appeal 41/2013. Sections 91 and 92 of the Evidence Ordinance prevents leading evidence to prove or disprove a written document. But section 83 of the Trust Ordinance provides that if one can prove that in attendant circumstances the donor did not intended to transfer the beneficial interest, even though the document appears to speak otherwise, constructive trust will be formed. Then we will see another case also here. Sulfika versus Silavangsa, Supreme Court Appeal number 8A/2010, decided in 2012. The respondent instituted action seeking a declaration of title of the property, eviction of appellant who was in unlawful possession of the property. There had been an outright transfer by the appellant to the respondent of such land. This was challenged by the appellant, who alleged that the purported transfer on the deed was merely to secure the loan of 11,000 rupees given by respondent. Property was to be held on trust until such loan was repaid. Then the issue here, one side there is a absolute, or there is an absolute or outright transfer. The other side, this is transfer for the purpose of securing the loan given by respondent. The property was to be held on trust. That was argued by appellant. Then two attendant circumstances which the court considered were the allegations pertaining to the undervaluing of the property in the deed of transfer. The respondent's husband's alleged employment as money lender. The money lender, in the sense he always lending money and get a property for as security. The appellant alleges that the value of the property mentioned in the deed was significantly below the market value at the time, as amount on the deed was intended to reflect the sum actually taken as loan from the respondent. The appellant alleges that the value of the property mentioned in the deed was significantly below the market value at the time, as amount on the deed was intended to reflect sum actually taken as loan from the respondent. Then really speaking, the market value is something more than the actual price of such transaction. The court notes that the deed of transfer in 1986 values the land 11,000 rupees, and the previous deed valued such land 5,000 rupees, 5,600 rupees. The property had not been undervalued on the deed of transfer, because when you see the time period between the previous deed of transfer and present deed of transfer, more than 1 year, then the price of the property always appreciates. Therefore, now earlier previous deed it was 5,600 rupees. Now it may be appreciated to 11,000 rupees. That's why here property had not been undervalued on the deed of transfer. In addition, the deed of transfer occurred in the presence of notary public, who would have expressly indicated the conditions of the transfer if there were any. And also, in this instance, if such transfer was to be temporary, and if the intention of the appellant was not to transfer the beneficial interest of the property, the notarial document would have been a mortgage bond rather than an outright transfer. Court more or less has gone beyond the trust and giving advice to the parties. The present case, without going for a deed or transfer, they would have gone for a mortgage bond. But court found that there was no attendant circumstances. That's very important. There were no attendant circumstances to suggest the existence of constructive trust, because there is no possession matter, there is no evidence in relation to the payment of notary charges or stamp duties. And also here, when you see the disparity of the price, there is nothing much. Therefore, the court said that here there is no constructive trust, because there is no attendant circumstances to establish that the transferor did not dispose the beneficial interest. Now, when you see Fernando versus Fernando, Supreme Court Appeal number 175/2010, decided very recently in 2017, once again court held in the above mentioned case that Section 2 of the Prevention of Frauds Ordinance and Section 92 of the Evidence Ordinance do not operate as a bar to lead parole evidence to prove a constructive trust and to prove that the transferor did not intend to dispose the beneficial interest in the property. This is a very recent case, but again the Supreme Court emphasized the point that Section 2 of the PFO's Prevention of Frauds Ordinance and Section 92 of the Evidence Ordinance do not operate as a bar to lead the parole evidence to prove the constructive trust. That is the end of Section 83 of the Trust Ordinance. Now we will move to Section 84 of the Trust Ordinance. This is also the section which is under Constructive Trust, Chapter 9. Now we will see where the property is transferred to one person. Property is transferred to one person for the consideration paid or provided. I highlighted 3 words here: a consideration paid or provided by another person. Plus, it appears that such other person did not intend to pay or provide such consideration for the benefit of transferee. Then the transferee must hold the property for the benefit of the person paying or providing consideration. The clear idea is here: property transferred to one person, consideration paid by another person, but the person who has paid the consideration did not intend to pay such consideration for the benefit of transferee. Then the transferee must hold the property for the benefit of the person who has paid such consideration. Now we will see this picture here. Now A transfers his property to B, but somebody must pay the consideration to A. Then C, the third person, when you see the transaction between A and B, but who has paid the money? C, third person. Then third person pays the consideration to A. That's fine. But C paid the consideration to A not for the benefit of B. C paid consideration to A not for the benefit of A. Then the next question you may ask, why did you pay? Then he paid for his beneficial interest. Then B must hold the property, transferee. Transfer A, transferee B. Then the transferee holds the property for the benefit of C. The English rule that where a purchase was made in the name of stranger, in the absence of proof to the contrary, the transferee was a trustee. Was adopted in Sri Lanka before 1918. Then what happened after 1918? Because 1917 trust ordinance came into operation. Then after this trust ordinance came into operation, section 84 of the trust ordinance deals with this situation. Section 84 of the trust ordinance has effected a change because a person who relies on it must prove two different things. First thing, he must prove that he has provided such consideration for the transaction. Second thing, he must prove that it was not for the benefit of transferee. Two things he must prove. First thing, he is the one who has paid the consideration, and second thing, I paid such consideration not for the benefit of transferee. Then where B is express trustee of some money for A. Now there is a separate trust there. The money, trust money with A. Sorry, the trust money belongs to A, but money given to B. Now B, the money is in the custody of B. B is an express trustee for A. And B uses that money with the A's consent to purchase a land. Then B is to be a trustee under section 84. The trust money with B. When B purchases a property, then B must be a trustee. This is one situation we understood. But another alternative remedy is there. Now B has the money. If he purchases a property with the consent of A, then again B is to be a trustee under section 84. But if it happens, then what is the alternative remedy? An alternative remedy which was open to A here in this situation is to follow the property in a changed form in the trustee's hand under section 65(2) of the trust ordinance. Then what is a section 65(2)? Here you can see where the trustee has disposed of the trust property. Trustee disposed the trust property, and money or other property which was received therefore. Trustee disposed the trust property, and therefore he got some more money because he disposed the money, or he disposed the trust property in the sense Say suppose there's a land which was under trust. The trustee sold the property, land, and he got money. Now, in changed form, the trust property in a changed form as liquid money, which is in the hands of trustee. Or other property which he has received therefore. Sometimes he has exchange of property. He has transferred this property to another person, trust property. Another person has transferred some other property to trustee. Then those are the two circumstances. Then can be traced in the hands, in his hands or the hands of legal representative or legatee, the beneficiary has in respect thereof the rights nearly as may be the same as his rights in respect of original trust property. Now, original trust property, as we have seen in the example, he had a land on trust. Then the trustee sold the property. Suppose, forget about everything, and suppose now the land sold by trustee and he has the liquid money there. Then the beneficiary has the power to follow the property in a changed form in the hands of trustee and declare that he holds that property for the benefit of him. That's why here we say that the section speaks that beneficiary has the right as nearly as same. The beneficiary has the right as nearly as same in respect of original trust property, that's the land. Now he has, the trustee converted that into the cash. Then again in the example that we have seen, the beneficiary has the same rights in the liquid money. That's another alternative view. Now we will see in this case Daniel versus Anolis. It was held that the plaintiff must prove that he paid consideration and he paid so not for the benefit of defendant, as we have seen in the earlier example also in terms of section 84. First thing, we must pay the person who claims the constructive trust under section 84 of the Trusts Ordinance. First place, he must prove that he has paid the consideration and also he paid such consideration not for the benefit of defendant. Now another case we see here, Maricard versus Lebbe. Out of the money which the defendant was holding in trust for plaintiff, certain immoral property was brought. A certain immoral property was purchased in the name of defendant. Actually, the liquid money was in the hands of plaintiff, and the plaintiff purchased a property now in the name of defendant. Held that under section 84 of the Trusts Ordinance, the plaintiff was entitled to a declaration that the defendant held the property as trustee for the plaintiff and to the conveyance of premises by defendant to the plaintiff. Then this is, I have taken from L.J.M. Hoore's book. L.J.M. Hoore cited and summarized the situation which may arise under section 84 of the Trust Ordinance. The following situation may arise where A's money is used and conveyance is taken in B's name. Say suppose A has given the money to B, but B utilize such money, A has given the money to B has the custody of such money, and B purchase a property in B's name. Then the first situation here, money is used and conveyance is taken with the consent of A. A agreed to do that, then he does accordingly. Second situation here, money is used with the A's consent, but B has disregarded the instruction to purchase in A's name. A has given the money to B, but A asked to purchase a property in A's name, but B purchased in his name. The third situation here, money is used without A's consent. The first one we have seen, the consent is given. But here in the second one, the third one, without consent. Money is used without A's consent. B having used A's money, which was in care and possession. Care and possession. Then the fourth situation we will see. The money is used with A's consent, but B has disregarded the instruction to purchase in the name of C. A consented to buy a property, but A asked to purchase a property in the name of C, but B purchased in his name. Finally, A pays the money and directs that conveyance should be taken to B, or conveyance to be issued to B. These are the 5 circumstances. Now we will see some other 2 circumstances that we will see later. In this one, before we go to this one detail, we will see the case here. Gould versus Inasi Thambi, 9 NLR, page number 177. The plaintiff employed the defendant to purchase a property for him. It was understood between the parties like plaintiff and defendant that the plaintiff should pay purchase money and that the defendant should get the conveyance in his own name. Thereafter, should subsequently reconvey the property to plaintiff. Plaintiff has given the money, but the defendant must purchase a property. Defendant purchased the property in his name, and thereafter that should be retransferred to plaintiff. It was the understanding. The defendant having refused to reconvey the property, the plaintiff raised this action to compel him to do so. Defendant pleaded section 2 of Prevention of Frauds Ordinance in bar of plaintiff's claim. Held that plaintiff was entitled to maintain action notwithstanding the absence of any notarial instrument signed by defendant agreeing to reconvey the property. Now in this case, what happened? The Moncrief J thought a situation in one. What's a situation in one? Money is used and conveyance is taken with A's consent. In that situation, A's right was to conveyance, while in 2, transaction was to be set aside because of fraud. Because why it's like that, situation 2, because money is used with the A's consent, there is no issue, but B has disregarded the instruction to purchase in A's name. A has given the money to B and A asked B to purchase the property in A's name, but B purchased in his name. That's why in violence 2, that's the situation 2, the transaction was set aside because of the fraud. Perhaps on the basis that the former was resulting trust and the latter constructive trust. Now we will see another case, Arunachalam Chetty versus Somasundaram Chetty, 21 NLR 389. Where a property was conveyed to Chetty with a firm name, it was held that property was transferred to him as agent of the firm and not in private capacity. As Chetty, to whom the property was so conveyed, was express trustee and not constructive trustee, it was not open to him to plead prescription as against other members of the firm. That's clear. Now we move to second paragraph here. An express trust can only arise between beneficiary and his trustee. A constructive trust is one which arises when a stranger to the trust already constituted is held by court to be bound in good faith and good conscience by the trust in consequence of his conduct or behavior. Conduct in the sense it includes transactions. Express trust in the sense it should be in terms of Chapter 2 of the Trusts Ordinance. Constructive trust that we are seeing now under Chapter 9 of the Trust Ordinance. If the property transferred to somebody, as we have seen section 83 and 84, in the first place, in terms of section 83, owner of the property transferred to another person. He is a stranger, it's a third party, but he becomes a trustee of the property because of his conduct and behavior. Right, we will move to another slide here. Sangrappillai versus Kandaya, 19 is NLR 389. A agreed to buy a land from B and paid the purchase money. But fearing some litigation, obtained a conveyance in the name of C without C's knowledge. Fine. Now, A purchased the land from B, A paid money, but the deed of transfer, in the deed of transfer, he mentioned C as transferee, buyer or purchaser. A informed to C subsequently of the execution of the deed in C's favor, and C also agreed on it and agreed to transfer such land to A whenever asked to do so. Held that C held the land in trust for A, and that A could claim or maintain any action for conveyance for a land from C, or if C had parted with the land, then recover its value. But here we must consider, if the trust is arising or the trust arises in relation to such property, then the A is entitled to ask for a conveyance, not the value. Now the issue is paid or provided in section 84. If paid or provided implies handling of the consideration, this might include item 3, the situation 3. Situation 3, money is used without A's consent. We having used A's money which was in his possession. But 3 has consistently had been assumed to fall within the section 84. Then the 4, situation 4, the money is used with the A's consent, but B disregarded instruction to purchase in the name of C. That's the issue now when you apply the section 84 to this situation, because A paid consideration, A not paid consideration here, A provided consideration, because A gave the money to B, B holds such money and B purchased. Before that, B got the consent from the A. A also agreed to purchase, but A said that you must purchase in my name. But A asked to purchase the property in the C's name, third person's name, but B purchased in his name. Then the issue here, when you apply section 84, the claim that the constructive trust arises in favor of a person who has paid the consideration, not anybody else. That's why here the item 4, there will be no trust for C because according to section 84 results to the person providing consideration. But here C, even though disregarded and we purchase in his name, but C can't be a the person who has paid consideration actually wanted to give the beneficial interest to C, but still under section 84 the trust cannot arise for C. That's why there will be no trust for C, because according to section the results to the person providing consideration. Now we will move to other slide here. These are the situation again. LJM Hure in his book cited that little bit problematical issues. We don't know whether the trust arises under section 84 of the trust ordinance. A's money which is loaned to B is used by B for purchase in B's name. A has given loan to B, now B utilized such money and purchased a property. Can we say that it is under section 84 of the trust ordinance? We don't know. Another situation here, A's money which is loaned to B is used and the conveyance is taken in A's name with B's consent to provide a security till B pays. B pays, right? Then in the sixth one, what we have seen now, A may rely on section 84 and it is met by B's claim that A provided consideration. The last situation that we have seen now, B is seeking to set up a trust under section 84 on the basis that he provided consideration. The famous jurist Levin and Scott both think that the situation last we have seen two situations would give rise to a trust, and similar conclusion could be reached on the construction of section 84. But there is no authority in Sri Lanka in relation to those situations. Now here another case we will see is Swaminathan versus Vandaputan. 37 NLR, page number 287. In this case, B intending to purchase a property for the big price 275,000, but he paid only 65,000 from his own money and borrowed how much? 210,000. Then altogether the price of the property was 275. He has paid out of his pocket 65. The balance 210,000 he borrowed from A. But the conveyance was taken in A's name as security to the repayment of loan. The Privy Council held that there was a trust without reference of any section. It may be in the reference act, really speaking, this is in relation to the equitable principles. On the basis of equitable principle, Privy Council held that. Now Pereira versus Tisera, 65 NLR, page number 257. Widow of an intestate transferred her half share of certain lands to the administrator under an agreement, the object of which was to preserve the property for the minor children of the intestate. And by subsequent deed, which purported to be a deed of agreement between the administrator and guardian ad litem of the children, the administrator undertook to sell to the children the share of the land which he obtained upon a payment of certain sum of money within the stated period. Held that in the circumstances, a trust had been established in favor of children, and that all the monetary advantages obtained by the administration in dealing with the land transferred to him must be held by him in trust for the benefit of minors. This is another situation under section 84. Trust arises. It seems clear that section 83 and section 84, it is the intention of the parties at the time of transfer or purchase that is most important. Because in the first place we have seen attendant circumstances under section 83. 84 we say he has paid such consideration not for the benefit of transferee. Then all these things, all to both matters, It is the intention of the parties at the time of transfer, purchase. That is most important. Mendes versus Parameswamy. 62 NLR, page number 302. It was said that where property is transferred to one person for the consideration paid by another person, the statements made by the purchaser long after the transaction, in this case it was about 4.5 years then, and not contemporaneously, are not relevant under section 84 of the trust ordinance to show the consideration was not paid for the benefit of transferring. The same principle we can extend under section 83 also. It should be contemporaneous statement, like to establish the attendant circumstances under section 83. It is important that it should be contemporaneous circumstances. That's why in this case, Basanaka CJ thought that the contemporaneous statement alone are relevant to on the construction of 84. But we can extend that same theory and the concept to section 83 also. In this case, Adam G. versus Board of Review, sealing on housing property and others. The fifth respondent applied under section 13 of the sealing on housing property law to the Commission of National Housing to purchase a property. Sealing of property was there, now it was not in operation, but at that time it was in operation, but already whatever rights vested, then they can claim even now. But presently the sealing of housing property is not in operation. That's just to keep it in your mind. The fourth respondent refused the application as the premises had not been or had been used as business premises, because the sealing on housing property is applicable only in residential premises. But here then the argument was the fourth respondent refused the application as the premises had been used as business premises, being given to the boarders and lodgers from 1962 to 1972. The premises had been purchased in 1964 by Ali Boy Adam G., father of the petitioner. The application was resisted on the ground that these were business premises and petitioner was not in the position to purchase such premises. Held that it was prima facie evidence that the petitioner in the position to purchase a property, though she had not the means, her son, who was doing lucrative business, would buy them for her. Then here son purchased a property for mother. Such a purchase by son will not result a constructive trust in favor of son, because it would be a case where son is providing consideration for the benefit of mother. Now, what we have studied up to now, we have studied section 84 of the trust ordinance. In terms of section 84 of the trust ordinance, property is transferred to one person for the consideration paid or provided by another person. In addition to that, it appears that such other person did not intended to pay or provided such consideration for the benefit of transferee, then the transferee must hold the property for the benefit of person who has paid or provided such consideration. Paid or provided such consideration. We have seen certain circumstances, and also we have seen it should be a contemporaneous statement. Then only it can be taken as evidence by which we can prove the intention of the person who has paid such consideration. Now we will stop with this one. We will continue this part further in some other lectures. Thank you very much.